Ooh.
But I couldn't eat like the second half on the train because it's just rude. But now it's like cold.
Okay. Shall we start? Thank you for coffee, that's awesome. So, welcome back. We are really on the home straight. So today we're going to try and pull it all together by talking about takeovers. So let's make sure I can actually talk about takeovers. There we go. All right. So as you can see, I've decided I'm not going to talk through the learning objectives because there are a lot of them for this part. But basically, this whole day is designed around the learning objectives, and feel free to go back to them at any stage. So let's actually just consolidate for a moment and talk about what a takeover is. So anybody want to hazard a guess, a definition? What is a takeover?
When someone assumes control of another company.
So it's to do with taking control. Are there any particular... so what does taking control mean in that context? Or in...
Controlling votes.
Controlling votes?
Operations.
In operations?
The board.
Finances. So ultimately votes go to shareholders, don't they? Where operations go to management.
Right.
Yeah, is that... finances kind of sit in between those things in the sense that the people who are responsible for recording financial information, reporting financial information are company insiders. But clearly shareholders also have, they have an interest, an absolute interest in the finances, both from a capital perspective and from a return perspective. What kinds of entities are subject to takeovers?
Listed and unlisted companies.
That's throwing. Listed and unlisted companies. Well, we're going to talk about takeovers today in the context largely of listed companies. So if we're sort of following our little analogy through, let's assume that our little robot company that we started off with some founders as a solopreneur, that then issued some shares, became its own entity. It then went and listed on a stock exchange. It's now a listed company. While it was a listed company just yesterday, it bought another company. Now it's a larger group. And so we're going to look at takeovers in the context of listed companies in particular. But listed or unlisted, entities can assume control, to use Carly's language, of any other entity. We're not restricted to companies, and we are not restricted to listed companies. However, listed companies form the biggest package or group of companies that are subject to the takeovers regime in the Corporations Act. And so that's what we want to look at. The kinds of transactions we were talking about yesterday when we were talking about buying and selling businesses, they're takeover transactions. They just takeover transactions that don't fall within the criteria required for the law. So the takeovers law to apply. So I want you to be thinking about how that's different and why the takeovers regime exists and why we don't have that same structured approach to takeovers in the unlisted space or in the small cap space.
Takeovers are pretty unfriendly word, so really
Yeah.
avoid it.
Well, and so takeovers is an unfriendly word, and we tend to use this word merger all the time, even in the listed company space. And technically, Australia doesn't really have a merger law. The closest thing we have to it, and we will talk about it over the course of the day, is the schemes of arrangements. And again, even schemes, there is a kind of, because schemes of arrangements sit in the context of insolvency and issues relating to debtors, there is this kind of public feel that if we talk too much about a scheme, it sounds like the company is struggling, where actually the schemes just give a context or a framework that allows a reorganisation of share capital that will, with shareholder approval and the approval of the court, allow for the recreation of a new entity. And so when we talk about schemes, actually, you might need to remind me to remind you, but it's not just listed companies that might use a scheme to restructure their affairs. So here, in this subject, we talk about takeovers in the context of a process of gaining control of a company, and the language we use here is a target, by bidding under a formal process. Sorry about that. Didn't think that was coming. By bidding under a formal process for sufficient shares to achieve a takeover, to achieve that end. So transactions that are aimed at changing control of the voting power that can be exercised at a general meeting. So there are lots of different ways, though, as Billy just suggested a second ago, than just beyond voting power for affecting a transfer of corporate control. So we've been talking about this area, this idea of just selling and purchasing either assets, so the business, or shares, or even just issuing new shares to investors, all are ways of affecting changes in the ownership or the control of voting shares. But we can also change control through changing management. Effectively, schemes of arrangement we'll talk about towards the end of the day, and ultimately what we want to talk about this morning at least are formal on and off market takeover bids. I don't know how many you have had a look at, but that page with readings and resources for topic 5 has a lot of cases. I think there are 35 or something in there. There are a huge number of cases. There is a note with it that says, I'm not expecting that you've read them all. And to be quite frank, that list would probably benefit from an update. But it's basically a list that's taken from the Takeovers panel website of cases that illustrate a range of the points that we have here. And I've tried with the cases in that table to provide a really short summary of what that case is for, what it's about, what point it illustrates. And so, yeah, that's why I say it probably could be updated, because I did that a few years ago now. And there are newer cases that will make the similar points, but because it's done. Yeah, and so actually what you've just shown me now is the reasons for decisions, which is in fact the cases, takeover panel cases. That list that I've got in topic 5 for the reading and resources includes a lot of takeover panels cases, but some of them are also Supreme Court cases, etc. So we'll talk about how the panel fits into the regime. But the Takeovers panel, it's a quasi-tribunal. Well, it is a tribunal. It is, while ASIC is charged with regulating the Corporations Act, the Takeovers panel is responsible for considering various takeover activity and making declarations in circumstances where it believes or it considers there is unacceptable circumstances, is the language that is used. It's a pretty interesting tribunal. It's made up largely of practitioners, takeovers practitioners. There are some judges on the panel. When the tribunal meets to consider whether it needs to make a declaration, it's usually 3 panel members with a chair. Compared to other tribunals, their turnaround is amazingly fast because the market needs to respond very, very quickly. And so matters are often determined within days. I think I make the point up there on the slide. Yeah, the good thing is takeovers panel decisions are really easy to read. And again, if you look at them for no other purpose than being interested in how excellent corporate lawyers write, looking at the panel decisions for that purpose is a good thing. You will see that really short, to the point paragraphs. Everything is numbered, it's clear, it's active language, it's consistent language, and it very much reflects current practice. And if you look at who the panel members are and the firms that they come from, you will see that they are absolutely practitioners in the space. And they get straight to the point very, very quickly. And I think it's a good thing for you to have a look at. One of the reasons the list is so long is, as I've mentioned before, that the particularly first iteration of this course had a lot more focus on the takeovers panel stuff, and like many academics and many lawyers, I'm much better at adding new stuff than I am at taking old stuff away. And so there is a lot of reading content in this section, but I want you to be, what we're going to focus on is the things that we talk about in the class, and you will see from the discussion questions, you will be able to decide your own path as to what interests you, as to where you're going to do your research and move from there. So control is measured from a takeover perspective, my thinking about votes. But before we talk about votes, I want to make sure we've got a common understanding of what control actually means. And so that goes to voting power in the sense that voting power ultimately decides who the management of a company is. But I think even from our discussions so far and from the work that you would have done in company law, for those of you who've done it, you can see that there's a sort of this assumption that the shareholders decide who the board is, which doesn't necessarily really bear out in public. Shareholders cannot appoint directors. They have a veto power. If directors appoint a new director and the shareholders don't like that new director, at the next at the next general meeting of the company, shareholders have the opportunity to vote against. But one of the things that is really interesting is how few people actually vote in shareholder meetings. Very few people vote. So what actually happens is institutions have huge amounts of control. And a lot of work has been done by activists in particular over recent years to get, in particular, superannuation funds to exercise their votes. So, there's a lot of work is done in proxy building in particular, but in getting, sorry, I'll turn my phone off again. In getting, particularly in relation to remuneration votes, superannuation companies just to cast a vote. Because for a very long time, mostly, it's only insiders who actually front up. I'm not saying that the superannuation funds or individual investors didn't have the right to vote. They've always had the right to vote, but they actually just didn't do it. And I know myself how actually easy it is to not exercise your vote. And there's a lot of work has been done by behavioural economists. I think I mentioned Dan O'Reilly last time we met, who does a lot of work in how it is that people make decisions. There's a lot of research that shows that when a decision is a difficult decision, people just don't do anything. So the default position is to not vote, because every time you ask to vote at a company meeting, you get a whole heap of information. And then for most people, it's like, well, I could just go and vote. And of course, the easy piece to read is how the board wants you to vote. Yes, yes, yes. The difficult thing is, what do you do with those votes? I've worked out that does not affect the recording, but the flickering goes insane for me. So I think thinking about voting. So why am I going on about this? Well, why do I go on about anything really? But why, for your final essay in this subject, there is a critical analysis piece here. And each time, because we are thinking about disclosure, we're thinking about how the regimes work, you can focus that on any part that you wish to. She says, having not read the assessment task recently, so I will do that and make sure that I'm saying the right thing. But I think the more different ways that you think about how these regimes work in practice, and particularly the impact on shareholders, the more interesting avenues you have to go down as you think about that critical analysis piece. So thinking about control, clearly control can come from a whole lot of different places. The work that I've got here, I'm just going to pull them all down quickly. At the peak, owning everything, owning 100% is absolute control, clearly. And when we talk about, particularly with small business, often that's the situation. You've got absolute control because an individual not only owns all of the shares, controls all of the votes, but they also are management of the company itself. If we're talking about listed companies, can somebody own 100% of the shares in a listed company?
No.
Technically, the short answer is no. Because of the way the regime works, you can get to 90% and a company still be listed. And if you did nothing more and the remaining shareholders did nothing more, it would be sitting there at 90-10, and you would remain listed. Clearly you don't own 100%, but you have effective control over absolutely everything else, which is why the compulsory acquisition and compulsory divestment provisions sit in place. But as part of that exercise of mopping up minorities, which is the language we tend to use, so at 90%, a shareholder or consolidation of associates who hold can require the remaining 10% to sell their shares to them, or the remaining 10% can require the 90% to purchase their shares from them. It's kind of a statutory drag-along, tag-along set of rights. At that level, when those provisions are affected, the consequences are that the company will become delisted. And one of the reasons why you need to achieve that is because the costs of being listed and the benefits of being listed, the costs will outweigh the benefits of being listed at that stage. And there is no market for shares when 90% of the shares are closely held. Yes. Yeah, there are a number of companies that sit right. A lot of the Western Australian mining companies too tend to sit up around those very high numbers, and they work very hard to just stay in. And one of the reasons for that can be that, so Virgin's a good example. Virgin is effectively part of a global group. The global group has financing arrangements in place. Again, I'm guessing now, but based more on experience than anything else. Those financing arrangements will include arrangements with banks that will require the assets to be able to be valued in a particular way or to be listed. And so that sort of maintains their transparency, and that it's effectively, it's like a version of having loan ratios in other financing. once you've got the entitlement to a simple majority of votes at a general meeting, that is an element of control as well. At 50%, you can veto an incoming director. They're actually sitting in a funny order here. The one that's missing is at 75%. At 75%, you can pass an extraordinary resolution, which effectively means you can change the name of the company, you can change its business, you can really decide who the board member is going to be. You really do have effective control, but you don't have universal control. Boardroom control is really interesting because that can be much less easy to see. So particularly when you have companies that invest, might even have less than 10% holdings, but have a representative on the board, they can have effective operational control even though they don't have any direct significant shareholding. I've put consolidation of accounts in there because if you have a level of control that's sufficient to require a consolidation of the accounts of a target into an entity that's controlled by the bidder, you've effectively got a financial control. You've got that ability to bundle a business in with your larger business. So there are lots of different ways of achieving the same thing. And 100% ownership, of course, is absolutely it. So I want to talk a bit about what kind of transactions there are. So we're primarily concerned here. Oh, goodness me. It's going to rain somewhere. We're primarily concerned with changes that impact public companies for this purpose. So where a change occurs because there's a change of control over the shares of a public company is what we're most interested in. But the rules apply in a broader sense. So it's worth remembering that most companies are private companies and the regime just doesn't apply to them. But if we're thinking about listed companies, all listed companies are public companies. But we also have public companies that are unlisted, and when they have more than 50 shareholders, these rules will apply to them as well, even though they aren't listed companies. It's also worth remembering that just because you're listed doesn't mean you are a company, and in relation to MISs, so managed investment schemes, foreign entities, and trusts, the rules may or they may not apply. So in particular, dual listed entities. So a dual listed entity is technically an entity that is simultaneously listed in two markets. So it is actually possible to have a primary listing and then have secondary listings on other markets. But dual listed companies are companies like Rio Tinto and BHP,
The only two Australian,
which are the only two dual listed here, where in fact technically they are merged entities. There is actually, BHP, the original Broken Hill Proprietary, is listed here. Billiton is listed in the UK, but they are effectively, there's a dual listing. It's a complex transaction, but they are simultaneously listed in the same place. So when you have companies that are listed on multiple exchanges, dual listed companies, these rules will apply. But a multiple exchange listed company, it might be a foreign entity. If its primary exchange is somewhere else, then ASX will have agreed that the equivalent takeover provisions and other significant listing provisions that apply in that other place will apply to this company. So they will just need, the idea is not to duplicate reporting. And then we have, of course, a whole lot of other type of non-company entities that fall outside companies and are not listed entities. And again, unlisted MIS, unlisted trusts, foreign entities that are not listed, and unincorporated associations and partnerships. These rules are completely outside of that regime. So the way that an incorporated association takes over another incorporated association, I think there are plenty of movies about bowling clubs that become croquet clubs or the other way around. The regime here makes absolutely no difference in relation to those. So many of the relevant rules will apply to entities that are not listed, but not all of them. So in particular, unlisted public companies will, as reporting entities in particular, where you have 50 shareholders or more, or they're categorised as large companies, will still need to be mindful about the takeover provisions, and in particular the related party transactions elements. So, brace ourselves, we're getting into the legislation, and I want to start by just having a bit of an overview look at Chapter 6 and where it comes from. So, none of this is particularly new. The Eggleston Committee met in the late 60s and early 70s. It released a number of reports. I think there are 5 or 6 in all. Again, all of the reports are available on the Takeovers panel website. The key report is the second interim report, which is goes back to 1969. So, you thought the big news was man hitting the moon. It was actually a Takeovers panel and Australia coming up with a policy for what it is that was going to be important in the Takeovers regime. And I think this key statement, which is often referred to as the Eggleston Principles, is really the foundation of how the law as it works today has been built. So the committee agrees with the general principle that if a natural person or a corporation wishes to acquire control of a company by making a general offer to acquire all of the shares, or if that natural person or corporation wishes to make an offer for a proportion of those shares that is sufficient to enable an exercise of voting control, that person or entity should be limited, or their freedom of action should be limited, in order to ensure the following 4 things. We need to know who that person is. So the shareholders and the directors should know who it is who is making that offer. The shareholders and the directors have a reasonable time in which to consider the offer that they're being given. That the offer itself needs to include all the information that's necessary to enable shareholders to form a judgment on the merits of the proposal, and in particular, if the offeror is offering shares as opposed to cash in another company, that the kind of information which would ordinarily be provided in a prospectus is given to those new shareholders or the offeree shareholders. And as so far as is practicable, each shareholder should have an equal opportunity to participate in the benefits offered. So let's just unpack each of those quickly one by one, because this is actually the core of what you need to understand why takeovers rules work the way that they do. So why do you think Eggleston or the committee thought that knowing who an offeror is something that is important?
Because you need to know what sort of percentage of shares they actually control.
So I think you're jumping a couple of steps ahead. So an offeror is somebody who is offering to buy either all of the shares or a proportion of them. So you've gone straight to, I need to know from the beginning how much they already control or how much they will control at the end. But why do we need to understand who that person is? So if I'm making a bid, I don't own any shares. It could just say, tell us how much interest they already have, but it's going straight to who am I? If I'm making a bid for shares, or a company that I own is making a bid for shares, why does it matter?
Go to their motivations for the transaction.
So directors and shareholders can be thinking about what's the motivation. So again, we just mentioned Virgin before. If Virgin, the founding shareholders, so companies associated with or ultimately controlled by Branson, control 88% of the shares there. If somebody is making an offer to buy some shares from Richard Branson or making an offer to buy more shares in Virgin, whether that's buying shares from the Branson Group or buying some of that 22% that's in the market, do I care who that person is? If that person is an investment bank, is it any different from if it's Qantas or Singapore Airlines?
So you are looking at the competition. There might actually be competition here.
There might actually be competition here. There might be a potential change in the business. There might be a potential improvement in the business. If let me pick, you know the old joke, the best way to make $1 million? Start with $1 billion and buy an airline. So Virgin might not be the best example, but so if we're using, if somebody was making a bid to buy 50% of Branson shares, Branson held shares in Virgin, and that bidder was one of the Emirates Airlines, so one of
Etihad has shares in it, so choose
Okay, Etihad. Okay, choose Etihad.
And Singapore
So-
has shares.
Yeah.
So Etihad looking to buy 50% or more, very well funded existing airline. How do you think, if you were already an investor in Virgin, would you want to hold on to your shares with that new investor in there, or would you be happy to sell them? Well, I wouldn't be holding airlines to start off with, so. But yes, shall I pick a better example? Okay, let me use a better example. Think of CSIRO, one of the biggest companies in Australia, and it basically makes blood serum products and and vaccines and.
What's CSI?
Sorry, CSI. What have I? Sorry, yes, I said CSIRO, which is owned by the government, does research. Sorry about that. No, CSI. Large company in health. If a bid was being made for CSI shares by an entity that is involved in researching new drug products or marketing drug products, you might have an interest in, you would be believing that they can see some value that the rest of the market can't see because they have that industry connection. Probably the classic example is when companies that are involved in the building of mines or suddenly start to make investments in mining explorers. People think, maybe they know something that the rest of the market doesn't know. So there is that idea that if we know who's investing, we get a sense of what their strategy might be. We also can know, if it's a listed company, whether or not there is another way of participating. If competitors are buying interests in each other, we can get a sense of whether or not there might be some kind of consolidation in the market. Ultimately, identity, that value, is as much as anything is associated with market transparency, with being able to identify what it is that's happening in a market. Interesting there that in the principles refer to both shareholders and directors, making it clear that the management of the company should know who it is that is making a bid. Why do you think that they have included the requirement that shareholders and directors have a reasonable time to consider a proposal?
If I want to see alternatives.
Yeah. Firstly, anybody needs time to consider a proposal, and that time does need to be reasonable to actually understand and be able to make recommendations that make sense. That on the whole, we do value in common law societies this concept, at least, of bargaining power, of a right to understand an offer that has been made to you, and that by putting unnecessary time pressure on people, that can be an unfair tactic. But again, as Michael really rightly points out here, by having the information in a particular timely fashion, it gives directors in particular time to analyse it and then either recommend or seek or recommend an alternative proposal. The offeror is required to give such information. Does this remind you of anything, this language here? It is. It's quite similar. Even though the prospectus obligations are much newer, they are closely tied in to this idea that shareholders have a right to form a judgment. So the language that's used in relation to a prospectus is to understand the rights attaching to the securities and the merits of the investment and the risks associated with the investment. It's slightly broader than what we have here. But basically, the value here is providing information. And the kind of information that is given when new shares are being offered in exchange for shares in the target should match the prospectus requirement. Why is that? If you're selling something, why do you need to know about another company? So if I run a listed company and my company is making a bid for another listed company, so we're going to move that, here's my listed company, there's another listed company, the idea is I'm going to acquire 100% of that company, and the people who were shareholders of the first company are going to become shareholders of my company, and that's going to be 100% owned down here.
You probably need to know, the shareholders, the purchasing company would need to know the effect on the holdings.
So there are two things that are going on exactly here. So let me just pull this up and I'll draw it so that you can all see it. She says, looking at her screen wildly. That one. Okay, so you just insert it. This must just drive you guys insane that I am very slow with this. But if we think about it like this, if we've got one listed company here and it does whatever it does, it has a business. We've got another listed company here and it has its business here. These have got shareholders, and I'll just change the colour to make it make a little bit more sense. We've got shareholders here. So this company is making a bid, it wants to merge these two businesses, right? So it's going to make a bid to acquire all of the shares in this company. The end consequence of that would look something like this. We've got the existing business that we had. We've now got another company, and we've got a business in here. And the original shareholders that we had there, we've now got some new ones that used to be shareholders over here. Sorry, over here. Me just pointing at it doesn't show you. So there are two lots of things that need to happen here. One is that these existing, my red shareholders, they need to they need to understand what it is that's being bought. Okay? But at the end of the day, they're just shareholders in an existing company. There will need to be market disclosure to them, but they really have no control, no impact over the company unless the number of shareholders that are coming in here mean that there is a change of control in this company. So from our original perspective, our original company that was sitting over to the side here, we've got shareholders in it, so it's got its business. It's got its shareholders that are sitting there. Those guys are getting two things. They need two things. Because what they're going to get first is information about that relates to the proposal to buy, but then they also need to have information about what these shares are, because they are effectively buying shares here. So even though the way I drew it, we had the old shareholders and the new shareholders, what's actually happening is they're cancelling those shares and they're going to get new shareholders shareholding in this company. So they need to understand what the rights and liabilities are attaching to their new investment. Well, that's what the Eggleston Principle suggests. Sorry, so let me just go backwards. So we're looking at two things. The information that's necessary to enable them to make a judgment as to whether they're better off holding on to the shares that they have or selling them to someone else. And then if the consideration for the price is shares in a new company, then they need to understand what those shares are worth, what the prospects are likely to be, not dissimilar to investing in that company from the very beginning. And then the last of these values is, so far as is practicable, each shareholder should have an equal opportunity to participate in the benefits offered. So what's that about?
Fairness, really. Making sure, for example, that the directors don't find a way to get beneficial treatment of their shares.
Yeah.
Whereas others can.
So it is. It's about trying to create a level playing field. So, but that can play out in lots of different ways. So if I am, I already own 30% of the company, and I have the opportunity to sell my 30% stake to somebody else, shouldn't I just be able to do that? This principle effectively would say, well, if you've got the ability to sell your shares, other shareholders should be able to sell their shares at the same price. So somebody might pay me a premium for my 30% shares because that gives them a big whack of control. So the market price for shares might be $1, but my 30%, I might be getting $1.20 a share. This principle says, well, actually, if you want to go and buy a proportion that's sufficient for you to exercise voting control, then, so far as is practicable, you need to give every shareholder an equal opportunity to participate in that offer. So it is. It's just about creating a level playing field. So let's actually have a look at how that plays out in legislation. So the first one is actually not from Eggleston, which is a little bit annoying, but the rest of them are, I promise. What I'm actually looking at is Section 602 of the Corporations Act. It basically requires each of the following things. An efficient and competitive and informed market. So this is just the general economic principle that markets work better if they are informed and competitive. Some of you may not agree with that, but we'll stick with it for the time being. Next, under 602, the identity of a bidder needs to be known. So the language we use here is a bidder is the offeror. A bidder is bidding for shares or securities in the target. Shareholders of the target are offerees, or target shareholders is other language that's used. So we need to know who they are. Offerees need a reasonable time to consider the proposal. They need enough information to assess the merits of a proposal, and they have a reasonable and equal opportunity to participate, and that there are appropriate procedures as a preliminary to compulsory acquisition. So before you actually can be required to sell shares, that there is an appropriate and fair procedure in place. So the principles, so the language in the section comes directly from the Eggleston Principles, which embody the philosophy of the legislation and are critical to bear in mind when assessing any action of a bidder, shareholder or target company. It's one of the areas of the law where, Dennis Danuto will be right at home. The vibe matters. So ASIC and the Takeovers panel have very broad discretion, particularly in relation to unacceptable circumstances. That what is important here is ensuring that the principles are achieved, and the regulatory device is to enable the principles, empower the regulator to enable the principles, as opposed to prescribe specific behaviours. At the same time, because of the nature of listed companies and the value that we have, that there should be an informed market, we do have much more prescriptive formats and templates for documents. And that's simply, the regulatory value there is we can compare apples with apples. If bidders' statements need to be made in the same format, and if there are competing bids, shareholders can put them side by side and work through them. So the underlying values are transparency and fairness. Transparency is about understanding who's seeking control, why they're seeking control, whether there's enough information to enable decision making. And fairness goes to the question of whether or not there's time to consider the proposal and whether or not shareholders can participate equally. So in Australia, the key regulation comes out of Chapter 6. There's the prohibition, and then we've got, let me go back a step. I'm going to bring it up here. I'm just pop a few slides on to find it. I just want to bring up section 602 for a second. I closed it, that's annoying. I'll just do it here where I can see for a second. Come on, wake up. Okay, go to Ostley. Jade's having a bad day. No, that's not going to come up either. So while I'm finding what I want to look at, does somebody want to share what you think I mean by the prohibition in 602? Silence is golden. Possess it if you can.
Okay, maybe it works like offering securities, issuing securities, in that unless you comply with all of the requirements therein, then you can't do a takeover.
Exactly. So the prohibition, basically the way law works is you cannot acquire an interest, a relevant interest in voting shares beyond the prescribed percentages. That's the basic prohibition, unless an exception applies. And then we work through what the exceptions are. So I just want to bring up the law so you've got something to look at here. I didn't realise I hadn't put it in the slide. I've just here we go. All right. The world is going to work for me eventually. Oh, here, I knew we had it some. Come on, load. Here we go. So basically 602 provides the actual prohibition and 611 sets out what the exceptions are. And I brought up 611 here. What I want to do, I'll go back. Of course, you guys are way better at using Ostley than I am because I never use it. Come on. 611, how far down can you be? Really long way by those things.
You just type in Google preparation.
That'd make it so much easier if I could just access it on a screen that you can see, that's all. So 602, and of course, as you can see, there is a ton going on before it. Let's just do it. So 602 basically sets out, so we've just been talking about it, sets out what the Eggleston principles are. Just don't do it to me. Okay, sorry, this is just annoying me too much because I can't move around Ostley in a clever way. Let me grab this instead. Now, in fact, what I'm going to do is, you get on your own screens to look at what the law is because that's just too hard for me to do. I just want to show you how the principles fit together. I'm just going to go straight back to this one.
It's 606 for the actual prohibition.
So 606 is the pro. That's what I was looking at, thinking, yeah. So pop backwards. I can just tell it's going to be one of those days, isn't it? This comes actually from the King and Wood Mallison's Takeovers, like brief guide to takeovers, which I think all the law firms put out guides to takeovers law. They tend to be focused a little bit on international clients. So some of particularly the King and Wood Mallison's one and the Allen's ones. I like the King and Wood Mallison's one the best. The Minters one is really good as well. Look, they're all good, but I've found you will find them easier to read than the textbook when it comes to working through what each of the provisions are. And the way I'm stumbling around this morning, probably easier to read than to listen to me, quite frankly. But I like the way that Mallison's, and maybe it's just because I'm a visual thinker as well, but they do quite a good job of pulling together the different ways that the different elements of the law work. So I thought that actually on this slide I had the information about the prohibition as well, but because of the way that it works, what we're doing is we start off with the principles. The prohibition is not in 602, it's in 606. But 602 sets up the framework for the chapter, and then from there we move through each of the principles, we get to the prohibition, and where you will spend most of your time is with 611. So 611 sets out what the exemptions are. But of course there's plenty of other relevant legislation that impacts these kind of transactions. And in particular, we need to be aware of Section 50 of the Competition and Consumer Act, and we also need to be aware of the Foreign Acquisitions and Takeovers Acts. And in the public space, that can, the FATA in particular, and the FIRB review, can really have significant impact. So in recent years, for example, we've seen the Singapore Stock Exchange make a bid for the ASX, which was ultimately halted because the Foreign Acquisitions, or the Treasurer, under the powers that the Treasurer has under the Foreign Acquisitions and Takeovers Act, said, no, this is, running a stock exchange is something that is in the Australian national interest. And so we are not going to allow foreign investment at that magnitude into the Australian Stock Exchange. Other places where we've seen FIRB come through have been in looking at the shareholding of Qantas, and also in listed company scenarios, we see it in relation to sorry, I'm just trying to think of good examples at the moment. Insurance companies as well. So there's also special purpose legislation. So privatised previously Commonwealth entities like Qantas and Commonwealth Bank and Telstra have special legislation that impacts the extent to which the takeovers regime is augmented. So on the whole, they provide that kind of legislation provides additional hoops as opposed to removing anything. And of course, the listing rules of the ASX are relevant only when a company is listed. So when we're talking about a takeover in the context of an unlisted public company, we're just dealing with the Corporations Act. But when we're dealing with a listed company, then we need to deal with both. So, also worth remembering that the law applies to transactions outside Australia if the transaction affects the control of voting power in an Australian company. So if an acquirer assumes control of a non-Australian company which holds more than 20% of the voting power in an ASX listed company, so a downstream transaction, then the takeovers rules apply. How that actually works in practice can be actually quite difficult to follow through with. But in the end, the penalty for a listed company, or what actually happens, is when there are upstream transactions that would breach the prohibition because appropriate disclosures haven't been made, you end up with a suspension of shares in the Australian market. If the rules have been followed in the upstream markets, then the ASX effectively allows for those rules to be used instead of the Australian rules. So if there's been a takeover transaction or a change of control in voting shares in a company that's on the London Stock Exchange, New York, NASDAQ, Toronto, the others that are listed there, which has the downstream effect of changing control in an Australian company, then it's considered to be a compliant transaction. So, prohibition generally, so 606, this is finally what I was looking for. This is where we start. So there are two parts to the rule in 606. So a person, and person here includes a company clearly, mustn't acquire control of, so notice it isn't ownership, but it's control of more than 20% of voting shares in a company unless that acquisition meets the requirements of the Chapter 6 regime. And a person who has control or influence over more than 20% but less than 90% of the voting shares cannot acquire control of any more shares unless they comply with the regime. So it's important to note that from 5% upwards, there is an obligation to disclose to the market that you have a relevant interest in shares. So at 5%, you have to tell the market that you have that interest, but it's only when an acquisition or a transaction of some type would change your relevant interest in voting shares so that it goes over 20%, do the rules kick in. And those rules continue until you hit 90%. And then at 90%, we have a different set of rules. And wouldn't you know it, in my notes, because clearly I've had this problem before, I've actually put all of the text of 606 so I can have a look at it as I talk to you about it. So clearly from the very beginning, we need to understand what it means to acquire a relevant interest. We need to understand what it means to have voting shares. So what it means to acquire that interest in voting shares. And we need to understand what it means to have voting power. So intuitively, most of those make sense, but most of the law has been around identifying what that relevant interest looks like. So the central rule, actually this is all going to say the same thing. So you can't acquire more than 20% unless the acquisition is in accordance with the legislation. Now, don't know what, sorry, clearly something's gone wrong there. Unless your exception applies. So we've spoken about this already, and I just got an annoying slide. So our 20%, our 20 elements in 611, going to annoy, sorry, my slides are annoying me today, so I can't imagine how annoyed you must be. Ultimately, the gateways look like the table that's on the slide. What I'm trying to do is summarise what those 20 exemptions actually look like. Could we just go out to lunch? Surely it's time.
Thanks.
Okay. So, first on the list here is off-market takeover bids. And that's where we'll spend most of our time today, because these are the most common transactions. So ultimately, off-market bid is a type of bid that's regulated by the law. The law prescribes the information that needs to be given and the approvals that need to be given. It allows for some conditions, and they tend to be friendly transactions. On-market takeover bids are acquisitions where the offer is made as a unilateral offer to all shareholders of a class. Those shareholders participate on market. So they effectively, the bidder stands in the market ready to buy at a particular price. Clearly, because it's happening on market, there can't be unusual or different conditions. They can only be, for example, an on-market bid can only be for cash. You can't make an on-market bid to issue shares in another company, because that needs to be an off-market bid. It needs to be a conditional bid. Schemes of arrangements are also a very common way, even though the schemes were all initially developed as a mechanism for addressing companies in distress. They provide a mechanism for restructuring capital, and they provide steps where there is both shareholder and court approval that is given to a scheme. So they are also very common ways of doing these transactions. Getting the approval of security holders. So basically going to the shareholders and getting their approval for a change. This is done less in a standard takeover where you've got one bidder who is seeking to increase their voting control. This is the exception that's generally used when a company does a capital raising. So if you are going to raise additional capital by diluting existing shareholders and issuing new shares into the market, whether that is by just offering them as part of a rights issue, or whether it is as you've isolated a new investor or group of investors who will underwrite that issue, the easiest way to do that is to seek shareholder approval. There is a mechanism in the listing rules where there is a percentage of capital that can be available for new issues every year without shareholder approval. And if those issues result in a change to the voting control of a prohibited nature, then that shareholders' approval basically can follow from there. The thing that's happening every day is the creeping acquisition. So once you have 20%, you can still buy in the market. You are just limited to buying no more than 3% in any 6-month rolling period. Every time your holding changes by more than 1%, you have to disclose it to the market. But you are not breaching the takeovers provisions, provided that the maximum amount that you purchase in a period is, or in a 6-month period, is not more than 3. Mentioned rights issues a second ago. I will just stop and check though. We understand what a rights issue is. It is the issue by a company of offers to existing shareholders to purchase shares, and that right to purchase shares, so it's like an option in a sense, is linked to the number of shares they already have. So my company Domicom did a rights issue a couple of weeks ago where effectively every shareholder had the right to subscribe for 1 new share for every 7.8 shares or something that they held. I can't remember what it was exactly. And that was a renounceable rights issue. So you could take it up or you could renounce it, and any amounts that were left over would be picked up by an underwriter and then sold into the market. And so because it's a renounceable rights issue, that means so if every shareholder just participates in proportion to their existing shares, there's not going to be any change in voting control, right? We've just got new shares issued, but everybody's participated. It never happens that everybody participates. And so you will always have a change in voting control that happens as a consequence of that. But say if we've got just a rights issue where everybody has the right to participate, then effectively the Eggleston principles are saying, well, it's fair, provided you're getting the kind of information that you need to get, and the rights issue, the rules about the documentation that's required for a rights issue require that transparency, and it's fair, you've got the right to participate, and newcomers and insiders don't have a different set of rights from all of the other shareholders, then we don't need to go through this regime. Underwriting. So acquisitions by an underwriter of an issue made pursuant to a prospectus or a disclosure document. Disclosure document here would incorporate the kind of disclosure you need to do for a rights issue. So why do we think an underwriter gets to pick up additional shares without having to comply?
I guess they might have picked up somewhere else. Is that right?
Ultimately, yes. So this is an efficiency provision because underwriting is about ensuring that the company can achieve the financial capital raising targets that they're looking for. And so the fairness goes to the prospectus. It goes to, so the document, transparency is looked at in the prospectus, in the rights issue documents, in even a scheme of arrangement might be underwritten. So it's really trying to avoid duplication here. And then downstream acquisition. So an indirect acquisition resulting from an acquisition of securities upstream, which itself has a relevant interest in a downstream listed company. And again, because there is disclosure at the key transaction, the transparency objective is met. And the fairness objective is dealt with on the basis that there's no actual change to the company's shareholding. There is just an upstream change to the voting power that shareholding holds. And so there is opportunity to get access to that information, and effectively I think that ASX just thinks shareholders can vote by selling their shares if they want to. So I want you to think about, do these gateways actually achieve the things that Eggleston was looking for? And even go back to, is Eggleston looking for the right things? Like, are these, the Eggleston principles are old now. They're 50 years old. Since those principles that drive this legislation. And the technologies and the way that markets operate now are very different. So when Eggleston came into being, there really was a lack of transparency. Just if you think about how difficult it would be to get information about companies in 1969 compared to about now. There was no hot copper. There was no internet. You couldn't, companies, if you wanted to find out what a company was doing, you couldn't go to its website. You had to go to its premises and see what it was doing. Again, I know I bore you with these stories, but as a junior lawyer, one of the things I was often doing was physically going to the stock exchange, to the library in the stock exchange, to pull out the volumes of company disclosures. Because when the companies disclosed, they sent a letter later on when they got high tech, a fax, to the stock exchange, and they would be held on a binder, and you would sort of have to go in there and open the volumes and read them. And people would steal things from the volumes, because traders, they're terrible humans sometimes, but you wouldn't necessarily find things. Looking at a share register was not a matter of paying some money and getting a CSV file. You literally went and looked at a paper register. So now that was in the 80s when Eggleston was 20-something years old. So I think when Eggleston started, transparency, don't get me wrong, I personally think transparency is a great value to have. But the problem was a different problem. Transparency isn't an issue in the way that it used to be. So again, I'm just trying to get you thinking in a way that will help you with your final essay as well, to think about, well, are these still the right rules? And do these rules actually achieve that?